on Wealth Radio Network.
Go.
This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, here's Gary.
More live. Ladies and gentlemen, boys and girls, happy Monday. This is Gary Quackenbush, your host of The Word on Wealth. So happy to have you along today. This is the show that you have tuned in. This is the show where we talk about everything you don't want to talk about. We know we need to talk about estate planning, about wills, trust, power of attorneys, about death and dying, and that's what we talk about on this day. And it's not even, it's not even a PG-13 show. It's nothing like that. This is family friendly, and we're happy to be here. If you have questions for me, we have lines open, and the phone will be answered by Noah, and he will put you on with me. The number is 888-344-1170, 888-344-1170. If you have questions regarding wills, trusts, power of attorneys, incapacity, guardianship designation, anything like that, I'm happy to take your calls. Also on Monday is the day that we talk about tax situations. So if you have a friend or a neighbor or a secret friend, or it's you or your business, and you have questions regarding a tax situation, I have Rich Mathurin coming up at the half hour, and he is an attorney here at GQ Law. He is an expert in tax problem solving. We're going to talk about that. That's our special day for you today on this wonderful day here. Same time, same station. Every week on Mondays, we talk about tax problem solving. So that will be, again, lines open, 888-344-1170. For the first part of the show, I want to talk about all things estate planning. And if you do have a question, please give me a call, 888-344-1170. 888-344-1170. I can answer your question, and I'll do the best I can. That's all I can promise. And I will probably know the answer. I don't get stumped much unless it's Noah that chimes in and asks me something that stumps me, but that's because Noah knows a lot about estate planning. The Secure Act, the Secure Act is an interesting, I always think I covered enough because I talk about it in my shows periodically, probably once a week. We end up bringing up the Secure Act. It's an act that came into play at the end of 2019, and it made a enormous difference on the way inherited IRAs are handled. What is an inherited IRA? Any retirement account that's a qualified fund, which is going to be a 401k, a 403b, IRA, Roth IRA. Anytime the owner of those type of accounts dies, they designate a beneficiary. If they don't designate a beneficiary, then the state designates a beneficiary, and that it just puts it goes into their probate estate. Okay. So if you are on the good end, the recipient end of an IRA, 401k, 403b, those things come to you as an inherited IRA. The IRA stands for Individual Retirement Arrangement, not account, but Individual Retirement Arrangement. And that individual retirement arrangement to you as the beneficiary is not called an IRA, it's called an inherited IRA. And it is a big difference between the two. If a spouse is the beneficiary, then that's an exception. It is then called a spousal IRA. It's not an inherited IRA, it's a spousal IRA. That means that you inherited it from your spouse, and it gets treated for tax purposes as if it were your own account. So think of it as your inherited IRA that you get from your spouse. It just goes and it adds to your own IRA. That means the rules regarding required minimum distributions, when you have to start taking money out, when you have to stop contributing, all those rules, as they apply to you, will now apply to this spousal IRA that you inherited. If you are not a spouse, then it is an inherited IRA. And the rules are changing, but what happened in 2019 is it made it so that if you inherit money as an IRA, you have 10 years to pull that money out. It's not like a regular IRA where you have for the rest of your life to pull the money out, and that you only have a required minimum distribution after you're already retirement age. And that could be under the Secure Act, it could be 72 years old. Then you would have to start pulling out required minimum distributions based on the rest of your life. Okay. But if it's an inherited IRA, it is not based on the rest of your life. It is 10 years. So from the date that the person that you inherited that money from dies, within the next 10 years, you have to pull it all out. Now that's really clear. We understand that. The IRS interprets it that way. The state of California understands it that way. Most people that know what they're talking about understand it that way. I talked to a financial advisor, just a couple of days ago at Neuberger Berman, great big investment house. And yes, that's the rule. It has to come out within 10 years. If you do not pull all the money out, and I don't mean spend it, I just mean you have to get it out of the IRA, the inherited IRA account. Okay. So the way it looks is, let's say your mom had an IRA and it had $200,000 in it. Her beneficiary says it goes to Debbie, my daughter. Okay. Mom dies. Debbie goes to the company, the IRA company. Then they say, oh yeah, it says it goes to Debbie. Prove you're Debbie. She proves she's Debbie, and they transfer it to her. It goes directly from mom's IRA to the new account that Debbie just opened and is called an inherited IRA. It can be in the same institution. It can be in wherever Debbie's got her money invested. It could be a new account. It doesn't matter, but it is called an inherited IRA. And the IRS knows about it because they were told when the transfer occurred, that transfer went to the beneficiary. The basis gets reset, all the stock, the taxable basis gets reset back to fair market value at the date of death. And now Debbie has 10 years to pull that money out. If she does not pull the money out within 10 years, then the amount that she should have pulled out will be penalized 50%. And they will treat it as if she pulled it out and tax it. Well, there's a good chance if you didn't take out enough within the 10 years, you're going to have a 50% IRS penalty. And the amount of money that's coming out is going to be the rest of it all in 1 year. And that could be, the personal income tax rate right now, the highest rate is 37.5%. That's going up. I can't imagine it going down. We're tossing out trillions of dollars from, we don't know where we're getting it from. The IRS is going to try to collect it from somewhere. So taxes, I don't imagine they're going to go down. So it'll be 37.5% probably.
90 seconds.
50% penalty, 37.5% tax. If I add those up, that sounds like 87.5%. That's like everything. So it's a good idea to figure out how your Secure Act affects your inherited IRA and make sure you get that money out within that 10-year period of time. Now, the big confusing part about the inherited IRA that I'm getting expert opinions on it, including from the IRS, is, are you supposed to take out something every year? And that's where the confusion is, because there's different opinions on it. The IRS has issued some
1 minute.
instructions saying this is how you're supposed to do it. And the one thing that we've heard as late as May was the IRS says if the person that died was old enough and was receiving required minimum distributions, they fell under that rule, required minimum distributions, then you, as the recipient of the inherited IRA, are supposed to be taking out at least as much as that person would have if it were their money. So it's like this, it's called this at least as rule. So you're supposed to be taking some money out, and you should have done it in 20 and 21. Those are things we're trying to tackle. We're going to have some experts coming up on the show to talk about that. Inherited IRAs are tricky. You got to get it right, or there's huge penalties. All right, coming up next, we are going to talk, we're finishing up a little bit about the Secure Act. If you want to call me, the number is 888-344-1170. If you want to talk about this in my office, it's 855-500-TRUST. And coming up next, we're going to keep on the show.
You've got questions. We've got answers.
Yeah, I said 90 seconds because I missed the 2 minutes because I was still in my brain.
Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there and filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Is there anything better than summer in San Diego? Out
For the legal help you need, call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQLaw.com. 500.
You're live.
All right. And that reminds me, I do have a website that's available that has a lot of free information on there. If you go to my website, it's gqlaw.com. Just remember, like my initials, GQ Law, LAW.com. So gqlaw.com. I've had the website for a super long time. There's a lot of information on there. There's a free book called Living Trust Basics, helps you understand how living trusts work. They're basics. So it's a good one. It's easy. It's free. Still available for free. Just go on my website, put in your email and your name, and it'll send it to you. There's also other books on there that talk about corporations and limited liability companies, the differences between the two, how they work, advantages, disadvantages. And a recent book that we put up is called the Tax Bankruptcy. So it has to do with tax problem solving. Some people just, sometimes things happen and you get to where you are so far behind in taxes that there just seems to be no way out. There's no clearing of the air, and we can do that sometimes with a bankruptcy. And it's always good to know if that's available if it's an available option. Okay, there are lines open. It's 888-344-1170, 888-344-1170. Feel free to call and ask your question, and I'd be happy to answer it for you right here on the air. The key to an inherited IRA and making sure that everything is taken care of is to understand what the beneficiary designation of your IRA is. Know where it goes. I talk to people on a regular basis, as in every day, about their inherited or their IRA designation, their 401k designation, where their annuities go, because I always talk about what happens after somebody dies or becomes incapacitated. That's my thing. That's my jam. That's what I do to try to help people make sure that they are organized if they become incapacitated or when they die. And we look at beneficiary designations. It's a very regular occasion where I ask who the beneficiary is, and I would say the majority of people don't know. They say, I think it's my wife and then my kids. I can't be sure. In blended families, the answer is typically, I don't know. When people set up a 401k with a company, when they hire on 15 years ago, they set it up, they designate beneficiaries, they get their life insurance as a benefit of their company, part of their pay, and they designate beneficiary, and they never think about it again. It's just something we don't think about. Those are the things you want to get with your plan administrator, go online, figure out your login, whatever, and know how your beneficiary designation is set up. If you didn't have kids when you first put in your beneficiary designation, I would bet you that you didn't list your children. So let's talk about listing children. If you list a child to receive your retirement account, and that's usually going to be secondary, you probably would say, on my death, I want my retirement account to go to my wife or husband. And if my spouse is no longer alive, then I want it to go to my children. Well, what if your kids are only, teenagers? Do you really want them to have the money that you've been saving up for the past 20 or 30 years? The answer is usually no. Are you kidding me? No way. Because it's money that took you 30 years to put away, 25 years to put away, and it's not going to take that long for them to spend it, because it just doesn't. Money that's given, as a gift to a financially immature person is nothing. It doesn't have any value. It's symbolic of what they can spend, and it doesn't really mean anything because it didn't take them 25 years to put together. So what I usually recommend is, in that situation, have it so that your alternate beneficiary is your trust. Now, you have to be careful, because if you want that inherited IRA money, the money that's going to go from your inherited or from your IRA to your children's inherited IRA, if you want it controlled by your successor trustee, the person that's managing your stuff and making sure that your kids get the money as they need it and when they are allowed to get it, like based on age or different behaviors or things that they have to do before they get money. If you want it to go through that process, the trust that you create needs to be a retirement protection trust. It can't be just the standard plain vanilla trust that we've been doing for ages. In 2015, we weren't even doing retirement protection trusts like we are now, because the laws, it didn't make sense. We didn't really need them that much. Now they're critical. So if you want to have your retirement account controlled as far as spending speed and when that money is actually available to your child or to your other beneficiary, then your trust has to be designed as an IRA conduit trust, or as we call it a retirement protection trust. It has to have language in that trust document that allows the trustee to manage distribution, how fast it gets distributed, how much they get it, how often they get it, what it can be used for. If your trustee is controlling that and your trust is not set up to allow that, it could accelerate how fast your child needs to pull the money out of that retirement account. Instead of being 10 years, it could accelerate it to 5. That's going to give you taxation twice as fast, and that's a bad thing. So if you want to have your trust reviewed to see whether it qualifies as a retirement protection trust, as an IRA conduit trust, that's something that we do. I review it for you. You bring in your trust with you. You try to get me a copy of the trust ahead of time, so at least I have it. I review it while you're in my office, and I check to make sure that the trust that you have qualifies for all the things you want it to qualify for. Is it a spendthrift trust? Does it stage out monies to kids based on ages and behaviors? Does it protect retirement accounts? Does it make it so that you can do other distributions? Is it what you want? That's the kind of stuff we do when I do free reviews for my listeners. 855-500-TRUST is the number to call. 855-500-TRUST. You can get a free appointment with me, and it is actually with me, Gary Quackenbush. I will review your trust and make sure that it's up to speed. It's what you need. And sometimes we would do an amendment to add in a retirement protection provision or an IRA conduit section. Other times we can start over and do a brand new one. Or if you don't have a trust, be happy to create a trust for you that meets your needs. 855-500-TRUST. Just get a hold of me. Happy to do it. And mention this show. Say, I heard Gary talking about it on the show today, and I want to have him review my trust, or I want him to do a trust for me. And you do that just by calling 855-500-TRUST. Pretty easy. 855-500-TRUST. I was just mentioning on the show last week about whether or not pets can inherit money, and had that question come up literally after I did the show. I had someone say, is that really true? Well, I try to tell the truth on the air, and yes, it is true. You can have a trust that's set up specifically for a pet. Most people say, oh, that's silly. I don't want to do that. Yet I have 2 cats and a dog that I care very much about, and I want to make sure that my friend Bonnie takes care of my animals. Well, that needs to be expressed and stated specifically in your trust, because pets, we own them. I know some people think that's the awful thing. I don't. We own the pets. They live with us, and they got to be taken care of. That's our responsibility as responsible pet owners. So you need to provide for them in the event of your death. What happens to them? Who takes care of them? And that can be put in your trust. And to encourage your friend, your potential new owner of your pets, to take the pets, then what I do a lot of times is you offer money. Like my pets are going to go to Jolie, who takes care of them, and for my gratitude of her taking the pet and to help her take care of them for the next 5 years, here's $10,000. And that's kind of the simplest way. And it usually gets the pets transferred. And if the people like the pets, they've got a little extra cash to help defray the cost of scratch marks on furniture and stuff like that. So that's probably the easiest way. I always think it's interesting when pet trusts come up, because it's something that some people are kind of embarrassed to talk about. So I really mention my pets, but yeah, you got to figure that out. It's like, we got to do it. All right. So what do you need now? Coming up at the half hour is we're going to get Rich Mathurin from GQ Law to come in, and we're going to be talking about tax situations, tax problems, and some of the new stuff that we heard recently about the IRS. But what I want to kind of finish up this segment is talking about what you need in an estate plan. It's not uncommon for people to not understand what estate planning is. If you think, well, I don't own a house, I don't need an estate plan. I don't have children, I don't need an estate plan. Those things really don't matter. If you don't have children, then I think there's more need for an estate plan, because there's no natural succession of your property. The California law says if you die and have a spouse, it goes, your property will go to your spouse, assuming it's community property. If it's separate property, your spouse gets, if you have no children, it'll go to your spouse. If you have children from another marriage or whatever, part of it will go to your children, part of it will go to your spouse. And sometimes that's really not ideal. You don't want it to go to your kids when your spouse, you're trying to take care of your spouse. So with an estate plan, you want to make sure that you're the one that put it together, and in that it does what you want it to do. Okay, so with an estate plan, a living trust is really important. If you have a house, if you have children, and you don't have to have both. If you have life insurance where you're leaving money to a loved one or loved ones, I say get a trust. Let the trustee handle that money. Let the trust handle that money, so that it doesn't just get handed to a minor beneficiary or somebody that's financially immature. So living trust, a certification of trust that comes along with a complete estate planning package. Wills, even though you have a trust, you need a will. And the will is called a pour over will. It pours over any assets that were left outside the trust. And usually that's going to be a car. Sometimes it'll be bank accounts. Today we just ran into a money account that was supposed to be in the trust. It wasn't. So we have to put it there with a probate petition. So you want to make sure your stuff is transferred to the trust. So that's part of what we're doing. You do transfer documents to show that your accounts were transferred. We do power of
90
attorneys as part of an estate plan. We do deeds to transfer the house to the trust. We correct your deed if it's backwards. Some people are married and own homes in joint tenants with right of survivorship. You should own your home as community property with right of survivorship. It makes a difference on how it's taxed after the first person passes away. So married couples, community property with right of survivorship, all California property. That's going to be my recommendation almost every single time.
1 minute.
Get your trust reviewed, and we can go and figure out whether you qualify because you have all of these things in your trust package. Living trust, trust certification, will, guardian designation, power of attorneys, transfer deeds to transfer the house to the trust, life insurance, healthcare directive, healthcare power of attorney. Those are the things you really need in every estate plan to make it so that it really will do what you're supposed to do. How important is it to keep originals? It is critical. If you do not have the original of your trust, that's a problem because a copy is no good. So look around if you have an older trust, and if you can't find that original, let's do a restatement quick while you still can, because you need an original trust and you need original wills. If it was stored by your attorney who's now out of business, you got a problem. Let's get it reset up. Call me at 855-500-TRUST. All right, coming up next, we've got Rich Mathurin from GQ Law and tax problem solving.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST. A friend about this broadcast outreach. The Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. gqlaw.com.
You're live.
All right, everybody, welcome to the Word on Wealth. Let's see, we're going to get you on screen there, Richard. There you go. All right, so you got Rich Mathurin from GQ Law. He's on for this second half of the show. I'm always happy to have him along on our Monday shows because it just seems like, you know, it's not like it's tax time like April 15th, but we do know that we are coming up on extension deadline for corporations is September 15th. And then extension deadline, the second extension deadline for personal income tax is October 15th. So those are a couple more deadlines for your tax professional. If you haven't gotten your tax professional the documents you need for your corporation, it's time. Don't wait any longer. Let's get that done. So, Rich, thanks for being on the show today again.
Great to be here again, Gary.
Yeah, so I really appreciate you coming on, and I shared this with you earlier as we got that one newsletter from our liaison, our contact at the IRS, and she had shared news with us that the IRS recently from Congress were allotted an additional $85 billion to their budget, and we know what the IRS does, but what do you think as a tax professional that the IRS is going to do with their extra $85 billion?
I do think probably the main focus is going to be on high income taxpayers that are avoiding taxes. That's what I've read. But I think that they will, there's going to be additional money for them to chase middle income and lower income taxpayers that haven't filed returns or haven't paid their balances. A lot of that is low hanging fruit for them, where they can garnish your wages or levy your bank accounts. So it's easier to track them down than to audit and chase around a high net worth individual.
Yeah, and it's like the report that I was reading through is that when they have the allocation of what they do with the money, and one of them was as far as the 45 of the 85 billion, 45 billion is going to go to collections to try to track down they're trying to shake the bushes and figure out who owes money and find it. So talk to us about that a little bit. What do you foresee happening when the IRS now has their newfound budget? And it's good. There's a lot of money out there that hasn't been collected. So what do you see happening when they get their new 45,000? Are you getting any kind of feelings now that things are getting more active? The IRS is collecting more, or they're trying to collect more?
Yes, maybe a couple of months back, it used to take me several tries and several hours to get through to their collections department. Now I call on our practitioner line and am able to get through pretty much quickly, answer the phone within 5 or 10 minutes. So that's a big change.
So that means that they got their collection department. I guess they're kind of beefing up their staffing and making so they can actually answer the phones, which is good for a guy like you that needs that availability to resolve people's problems. And I guess from a standpoint of good, they're going to collect more money. Bad from a standpoint, if you owe taxes, probably should get on it.
Yeah, definitely. I have also, in speaking with them, I have seen that maybe this is just my impression or whatever, but I think that they are more open to deals and lower, tax payments than would normally. They might accept a partial pay installment agreement where they're not taking full payment on your balance if you provide a financial statement and show that you don't have that full ability to pay. So I have noticed that the state of California, they also have been a little bit more easy to work with. I did get a hardship for one of our clients that had a pretty good monthly income. So, I think if you deal with the problems now, there is some more willingness on part of the taxing authorities to make deals than maybe in the past.
That really seems like something to take advantage of. It's like if the IRS, they have more money, they're starting to move forward, yet they still have kind of this thing from during the pandemic. You've told our listeners before that you've kind of had this feeling during the pandemic, you've been able to get things done as far as like partial payment installment agreements, even offers and compromise and settlements. And it seems like the IRS has been really pretty good and seemingly fair during the pandemic, but are you getting a feeling like they're going to still be doing that for a while and eventually it's going to come to an end? What's your take?
I do think that they're probably going to get tougher, but probably maybe till the end of the year we're talking about. So I think, in the fall, you still probably can get, some good agreements with them. I would also mention that one thing that is still I see is the bottleneck of their processing of returns that were filed by mail. A lot of clients that have filed a bunch of returns, they still haven't been processed when we run their tax reports. So that's one thing that's a disconnect I'm noticing from, the collections. They have ramped up the collections, but they still have not processed a lot of the returns that were filed during the pandemic.
So to find that out, then you've been able to And these are people that we're actually working with. You've been able to you can actually get into the IRS's records and see whether returns have been processed.
Yes. So, we
that's
have
cool.
a tax software that we run that produces a great report, shows whether the return has been filed or yes or no. If it's been filed, what's the tax balance owing? And then there's a lot of other information, when was it fall off under the statute of limitations? Would it be dischargeable in a bankruptcy? Payment history of the person, penalties and interest, whether you would be eligible for a penalty abatement, a lot of good information. But, I do check on some clients trying to track to see when their returns are processed, because it's kind of hard to get a client into a payment plan right now if only like 3 of their 10 returns have been processed and they're still missing 7. What's their actual balance? Is it 5,000 or is it 100,000? It could swing based on processing those returns.
So you can help people that haven't filed returns in 5, 6, 7, 8, 9, 10 years. Then it's not the end of the world. It's not hopeless. There is hope.
We have several that are working with our tax enrolled agent tax preparer that have not filed for 10, 15 years and trying to get them in compliance. Generally, the IRS and the Franchise Tax Board will not put you into a payment plan unless you have filed. For the IRS, it has to be at least the last 6 years. FTB seems to be saying we need at least the last 3 years. So, and
that seems fair. I mean, if you, you try to you owe back taxes and you haven't filed, and then you want some type of a deal or arrangement with the IRS or the state. And, their attitude is pretty much, well, while we've got your attention, and maybe they're hanging on to you, while we got your attention, we want these returns filed, or else we're going to involuntarily take your money. So it seems fair. But so on that note, I mean, you've got people that haven't filed in a bunch of years. And I think for a lot of people, we've talked about this where they have their head in the sand and they think, okay, I can't see what's coming, but the line is still charging, your rear end is in the air. I mean, it's like you stick your head in the sand, it's a bad idea. And yet we have, I don't know, it seems like if you haven't filed for that long, how on earth do you come up with numbers? How can you do an accurate return?
Our tax enrolled agent tax preparer that we refer a lot of our clients to is very good about kind of reconstructing people's histories with bank statements. Sometimes if you're in the similar industry, he will take a similar industry revenues and expenses and attribute that to try to do a tax return for you, but he's very good at preparing older returns that maybe not all the information is available.
And I guess that makes sense, right? If you're putting together a return and you're not 100% accurate on you can't remember all the deductions and the income, that report you're talking about, a lot, if there's income that you receive that's reported to the IRS, which would be like on a W-2 or 1099, we can get that information, right?
Yes, the report provides all that for 10 years going back, I believe.
Oh, that's great. So then we get that information, then our tax guy can go through and put together the returns. And it's interesting. I mean, some people, they haven't filed in so long and they're super paranoid and they want to get everything exactly right because they're worried, oh my gosh, if it's not perfect, the IRS is going to audit me. Yet they just haven't filed. And if the return isn't 100% accurate, the idea is we want to get them so the return is filed, they're in compliance, and we're trying to work some type of an arrangement. And if we're doing an offer in compromise where they're not going to have to pay the full balance, or if we're trying to do a partial pay installment agreement where they're not going to have to pay the full balance, or maybe even working a bankruptcy, it's like, I know it sounds flippant, but who cares if the return is 100% accurate? You can't afford to pay it. Get these returns done. Try to come up with a solution. And I know, we've been working, we've had you with us for a long time. And it's like some of these solutions, it's not a snap your fingers, do an overnight thing. Sometimes we have this track where it's like, we got to get the information. We got to file returns. We got to get collection delays with the IRS and the state. And then the returns get filed. And then you're working this thing for another 6 months or 12 months or 18 months, because you're trying to get to the point where you can implement a better solution.
Yeah, definitely. Especially with the pandemic, it's been a 1-2 year process with some clients.
That's wild. So you guys, if you have tax problems, if you have friends that have tax problems and family, give us a call. It's 855-500-TRUST. You can just call us at our regular number, 855-500-TRUST. There's a really good book that we have on the website, gqlaw.com, and it's called The Tax Bankruptcy, along with the information on how to get rid of taxes in bankruptcy. In that book, it talks about some of these things that Rich and I are talking about right now, the options for tax problem solving. So go on our website, gqlaw.com, and download the book. It's an orange book cover called The Tax Bankruptcy. Coming up next, we're going to talk to Rich about some other problem solvings for taxes coming up on the Word on Wealth.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
We're with Craig Smith of Borderland, your local source for cybersecurity. And Craig, why would someone need 24/7 monitoring if they could just get cyber insurance?
Well, cyber insurance offers some
Gary and the team at GQ Law, 855-500-TRUST. Or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQlaw.com, 855-500-TRUST.
You're live.
All right. Good to have you along. Happy Monday, everybody. And it's the moment we've all been waiting for. We talk about tax problem solving on Mondays. It's like, how many of you know someone that has a tax problem or that is struggling to pay their taxes? Especially we're coming up on the corporate tax deadline in about 17 days. And then we got the personal income tax extension deadline coming up October 15th. So it's always good to talk about it. The IRS recently has received a boost to their budget to help them collect money from people that owe money and haven't filed their tax returns. And that bump to their budget was $85 billion with the B. Of that $85 billion, we know that about $45 billion was applied to collections, which is the department that makes sure that they find the money and shake the trees. And one of the things that we have Rich doing is trying to, well, and very successfully helping people figure out what their problem is, what they need to do, and kind of head off the problems that we're seeing. And the best thing to go do, you guys, is if you have a tax problem, is deal with it now. Rich has been telling us that the IRS, with they're ramping up so that they can collect more money. Face it. I mean, the reality is we Our government needs to find a lot of money. They handed out a several $1 trillion during the pandemic over the last couple of years, and it has to come from somewhere. They can't print more money than they're printing. Inflation is already out of control. If they printed more money, then we got a bigger problem. So it's going to come from somewhere. The IRS has this thing called the tax gap, and they actually calculate how much people should have paid compared to what they've received. And that tax gap is a big focus of the IRS every year, trying to figure out how to, what they call, close the tax gap. What we call is how they're going to scratch the money out of people's bank accounts, out of their wages, out of their assets. And that's what they're doing. The IRS is the largest, most powerful collection agency in the world that employs 186,000 people. And it is designed to collect money. It is one of two departments in the federal government that actually makes money. One is the DEA. So you can imagine how they make their money by collecting money, fines and all that, and property of drug lords and whatever. The IRS getting money from we taxpayers. So we want to talk about that. So let's go back to Rich. And if you want to call and be part of the show, you can call us at 888-344-1170. That's 888-344-1170. And I want to talk to Rich about bankruptcy. Some people say, oh my gosh, you can't file bankruptcy on taxes. That's just one thing that will never go away. Talk to us, Rich, about there's a couple of types of bankruptcies we want to talk about with consumers. And then let's kind of go a little overview and then maybe talk about Chapter 13s and taxes a little bit.
Okay. There are two main types of bankruptcies for an individual consumer. Is the Chapter 7, that's a liquidation bankruptcy, where there is little or no assets to pay creditors. That is sort of an immediate, you file, and if the trustee determines that you don't have the assets to pay assets or income to pay creditors, you would get a discharge from your debts, usually about 3 months after filing. But if you do have excess assets or income, generally you would file what's called a Chapter 13 bankruptcy. That's a reorganization plan, usually 3 to 5 years. And your secured creditors, that's creditors that have a lien on your assets, would be paid in full. Your priority creditors, that's taxes and family support obligations, would be generally paid in full. They're priority creditors, but they're below secured. And then your unsecured creditors would be paid somewhere between 0 and 100 cents on the dollar, depending on your income and assets. So we would pay our arrearage on more. It's a good avenue for if you're behind on your mortgage and your arrearage is too high and you can't catch up and they're going to foreclose on you. Chapter 13 stops the foreclosure, and we put the arrearage, the mortgage, the interest payments that you owe into the plan, and you pay it off over usually 5 years. Taxes, those would generally be paid in full. That's both the IRS and the Franchise Tax Board would be paid in full with interest over 5 years for your back taxes. And then if there's money left over, your unsecured creditors would get some portion of your monthly payment. Your ongoing payments going forward for your mortgage would generally be paid outside the plan.
So the idea of the Chapter 13 is that it is a type of bankruptcy. We refer to it as like a mom and pop reorganization. So it works with like sole proprietor businesses. It works with individuals. Corporations can't file Chapter 13. So this is specifically for like individual taxpayers and businesses. So what we're doing then is it's a bankruptcy. And the advantage of that is that if you file the bankruptcy, what happens to all the creditors? Like immediately, what's the thing that happens right away?
The bankruptcy court issues what's called an automatic stay, and that stops all collection activities as of the date of filing. So if you have a foreclosure that's scheduled on Monday, you fax a notice of the filing to the foreclosure company and the lender, and they are required under the law to stop all collection activities, foreclosures, levies.
It literally stops the foreclosure sale right when they get that notification.
Yeah, exactly. So it's a very, very powerful weapon, tool to use to reorganize your life, your finances. And then everything has to be done through the bankruptcy court.
See, that's what I like about it, is that you have these creditors, the IRS, the state of California, the mortgage creditors, you have maybe credit cards or lawsuits or whatever, and they all come at you at different ways because they all have their different procedures and they may be suing you, whatever. But in the Chapter 13, all the creditors, they have to submit to the bankruptcy court. And now it's this reorganization. It's this organized process. Instead of this feeding frenzy against you that you're just not making it, you have this reorganization. That's what I love about the Chapter 13. Yeah. So once you get in the Chapter 13, the automatic stay stops all the creditors. What do you do at that point? How do the creditors like get in there and say, here's my bill and here's what I want? How does that all work?
Well, you and hopefully your attorney, I would definitely suggest working with an attorney on a Chapter 13, would file what's called the Chapter 13 plan. Okay. Like I said, it's usually minimum of 3 years, usually 5 years, where you would list who you're going to pay, what like I said, secure creditors that get paid in full on their like mortgage arrearage or your arrearage on your car, things like that. They're paid in full. Your taxes would be paid in full with interest. And then it would be some portion that would be paid over to the unsecured. Again, that can be zero if you have little or no income or assets left over, or it could be, 70, 80 cents on the dollar. It depends on the person's income and assets.
And that can include like old taxes too, right? I mean, if you have old taxes that are 3 years old and you filed them and all that stuff, those can be considered as non-priority unsecured creditors. So the potential in a Chapter 13 is you can actually reduce older taxes, like reduce them and pay them the 100 cents on a dollar all the way, sometimes down to zero, right?
Mm-hmm. Yes, definitely.
That is so cool.
And,
okay. So the creditors also, so then you put together this plan, it proposes to, people get paid a certain percentages, the secured, the unsecured, and then how do the creditors have to then come into the court? They have to file something, or how do we know what's owed?
Each creditor would have to file what's called a proof of claim, showing what they're owed and detailing that with the schedule of what invoices and that they are owed, and they would file that proof of claim. And the U.S. trustee, the government hires what's called a Chapter 13 trustee. He oversees the debtor's plan, and he suggests to the court whether to approve the plan or whether it needs refinement and things like that. Generally, there usually is some negotiation between the creditors, the trustee, and the debtor and its counsel to get to a satisfactory plan. And when they come to a satisfactory plan, the plan would be confirmed by the bankruptcy court.
Well, what if I'm in bankruptcy, Chapter 13, and a creditor submits a claim and I look at the claim and go, that's baloney. I'm not paying that. That's wrong. Can I do something about it?
Yes, you would file what's called an objection to the proof of claim, and detailing why you believe that it's not a legitimate claim, and then that would be ruled on by the judge in your bankruptcy court.
See, that seems to me, Rich, that seems to me to be really incredible, that these creditors, I mean, especially a lot of people that are getting chased around by creditors, maybe a lawsuit from an old personal injury or, debts because of a divorce or whatever. It just seems like, and even IRS chasing people around, it seems like sometimes people, they don't really owe. It hasn't really been determined and they feel like they're really getting an unfair shake. But now to say that there's this method where you can actually bring the creditors in front of a judge and you can challenge the numbers. I just think that is so powerful. I love that.
Yeah, I think what we've mentioned this before, you bring it up as a good point. It's another bite at the apple if you oppose what the IRS has assessed you. Say you appeal to them and your appeal went nowhere, and then you're in the bankruptcy court, and they file a proof of claim, you can object to their, whether 1 year of assessment or what number of years. So that's another bite at the apple through Chapter 13 on the IRS.
That is so cool, because sometimes, I mean, and in dealing with the tax problems, the thing, you guys, that Rich has dealt with quite a bit is sometimes people go through an audit, they've got some issue going on, that for some reason the audit goes the wrong way, something got messed up, they tried to do it themselves and it goes the wrong way. Sometimes you can actually use a Chapter 13 to get back in front of a judge and challenge the IRS's assessment. I think that's one of my favorite things about a Chapter 13 is you get this, like Rich is saying, the second bite at the apple. If you guys have situations like this, or family and friends that do, please call 855-500-TRUST. 855-500-TRUST. Go to our website, gqlaw.com, and download that free book, The Tax Bankruptcy, and learn all about this stuff for free. This is Gary Quackenbush and Rich Mathurin. Thanks, Rich, for being on the show.
Thanks for having me.
Right. See you tomorrow, everybody. We'll be back same time, same station.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help you preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual